Good afternoon. Welcome to the regularly scheduled meeting of the Community Development and Regulatory Services Committee for today, April 1st. I've been joined by council members Reich, Fry, and Kano, and Councilmember Warsame is on his way. Councilmember Quincy is unable to be here today. He is with his son. We have a relatively brief agenda. I'm first going to start with the consent agenda, which is items number 10, 11, and 12. They have to do with the recommended licenses for approval from staff, as well as rental license dwelling conditions for a number of properties in items number 11 and 12. Is there any item anyone would like to pull of items 10, 11, or 12? Seeing none, I'll move approval of the consent agenda. All in favor signify by saying aye. Aye. Any opposed? Those items are approved. We'll then move on to our discussion item, which is item number 13. I'm going to move to postpone this item one cycle. Are there any objections to that motion? Seeing none, all in favor signify by saying aye. Aye. Any opposed? That item has been postponed one cycle. We'll then move to our public hearing agenda. We're in the, we have the interpreter, so we can start. Okay, great, thank you. We'll start with item number 1, which is considering an ordinance amending Title 14, Chapter 364 of the Code of Ordinances relating to the provision of hearing protection devices by holders of qualifying liquor licenses. Is there going to be a staff report on this item?
Yes, Madam Chair, I'm prepared to make a brief one.
Okay, Mr. Wilson, thank you.
Thank you, Madam Chair. The amendment before you today will require all Class A and Class B on-sale liquor, wine, and beer licenses to make available free of charge to customers and employees hearing protection devices. Class A and B liquor establishments are generally our nightclub and theater type uses where there's live music played. The requirement imposed by this section shall not apply unless the licensed official has identified a source or supplier of hearing protection devices and to provide a sufficient number of these hearing protection devices to our club. So the establishments will be provided them for free. They have to make them available, and a supplier has been identified that will provide them. So we did do a notification of this public hearing. We notified all of our 185 Class A and Class B liquor establishments. We notified all business associations and neighborhood organizations. We did receive 10 responses to that. 9 were in support and 1 was opposed. And the opposition on that one was just questions on how the earplugs would be supplied to the establishments. Staff is recommending approval.
Okay, Councilmember Fry, did you have something you wanted to add?
Yes, thank you, Chair Gordon. Mr. Wilson, I believe there's going to be another 10 or so that will be forwarded to the for the record. I just had a couple quick questions, just to be exceedingly clear. This is 100% free for businesses, is that correct?
Madam Chair, Councilmember Fry, yes, these are being provided by a local manufacturer and providing to the clubs for free, and the ordinance will not be imposed or enforced against them if they do not have a supply of them free.
So I'll note that, for the record, that while we do presently have, these will be provided indefinitely into the future, if in the event they are not provided indefinitely, there is no longer a requirement on businesses, correct?
Madam Chair, Councilmember Fry, that is correct, and it states that in the amendment.
Thank you.
Okay, so we're going to take a public hearing on item number 1. There are 3 people who are signed up to testify. I will note that they are Carolyn Miller, Ann Knapp, and Robert Shalak. If the 3 of you would step forward, just stand in line, and if there's anyone else here who would like to testify on this issue, why don't you kind of come on up and we'll all get in line. We're going to allocate approximately 15 minutes to the public hearing and would ask you to try to keep your remarks to 2 or 3 minutes. And then just please state your name and address for the record.
Okay, my name's Robert Schlau. I'm a professor at the University of Minnesota in the Department of Speech Language Hearing Sciences. Thank you for this opportunity. I read a draft of the ordinance, and it listed the noise reduction rating as 30. Some of my colleagues have said that that number is too big, that it would distort the music, and people might not wear the earplugs if that were the case. So I'd like to add that. Also, I completed a study. I was a co-author on one back in 2006 where we had people wear meters that attended different concerts. This was out of state, so I don't know what the situation is here in Minnesota, but those meters showed that the levels during the concerts far exceeded safe levels, and that measurements we made of people's hearing before and after showed significant temporary threshold shifts. Earplugs prevented most of the shifts in those people. Until recently, we thought that temporary threshold shift didn't represent any harm to the auditory system because the clinical measures that we make show that hearing recovers after this temporary threshold shift. Well, recent data from animal studies show that there's extensive damage to the auditory nerve that occurs in animals that are given these temporary shifts. Hearing recovers completely, according to our clinical tools, but half of the neurons in the auditory nerve are missing following this damage. So this would cause problems for higher level sounds, like listening to speech in a background noise, like in a noisy restaurant. So people, up until just recently, we thought that they weren't at high risk because their hearing recovered. Now we're beginning to rethink that situation. So providing earplugs at these venues, I think, is an important consideration.
Thank you very much for your testimony. Next, please step forward, state your name and address for the record.
I'm Ann Knapp, and I'm a retired audiologist. I'm no longer licensed as an audiologist in the state, but I practiced audiology in a clinical setting. I'm at 215 10th Avenue South, and I wanted to speak on behalf of my patients, really, over 24 years of working in clinical situations with patients. I can tell you what hearing loss really means is isolation, withdrawal, and depression, and it really is a public health issue. And a number one type of preventable, cause of preventable hearing loss is noise, as Bert just indicated. And the other thing that I can mention to you is in the newspaper articles I read, the most current musician who was mentioned in any of the articles was Beethoven, which I think is unfortunate. Peter Townsend of The Who, if newspapers could pick up on that. He has a hearing education and awareness for rockers group because he can speak to the deleterious effects of noise. And you can find him on Wikipedia. And then the other issue that I just wanted to mention briefly is for the military and for military hearing loss is a big, big issue. And the compensation for the military and for workman's comp because of noise is really great. And that's just going to become greater in our society.
Thank you for your testimony. Welcome. Please state your name and address for the record.
Carolyn Miller. I'm 15 Glenwood in Minneapolis. Chairperson Goodman, council members, thank you for the opportunity to speak with you today. Firstly, I'd like to make it known that I'm well informed on the issues of hearing loss. Personally, I suffer from Meniere's disease. My goddaughter is deaf and is just benefiting from cochlear implants. My concerns about the ordinance are as follows. The management and owners of businesses that would be affected by this ordinance have been told that there would be no negative financial impact for the business. This is incorrect. There are businesses that sell earplugs. This ordinance would remove a revenue stream. Nate Krantz, GM of First Avenue, the nightclub, has provided me and allowed me to share with you the total revenues of sale of earplugs at First Avenue. First Avenue has experienced sales of $4,000 for the last 3 years, each year. This also equates to about $551 in sales tax that's generated. Any loss to our revenue stream is unacceptable, especially as the hospitality industry is looking at increased minimum wage. It's difficult for us to find additional areas for revenue. We're pretty much set on what we do. The Starkey Foundation, from Nate, the Starkey Foundation had approached First Avenue to see if they had an interest in a program that was essentially what this is. First Avenue asked what would be the benefit to us. The answer was none. First Avenue rejected it. I have an issue with the fact that now we're creating an ordinance that puts something that started off as a private interest that is now coming into an ordinance situation. I think that the proposed ordinance would put a necessary burden on the Class A and Class B when there are a lot of other businesses that have increased decibel levels that we're not addressing with this. As well, I'm concerned about the amount of limited space that each hospitality or any business has to sell the items and represent the items that we sell. That real estate, it comes at a very big expense. So, again, I think it should be rejected, and I appreciate your time.
Thank you for your testimony. So there are 3 other people that have signed up, Jean, Brian, and Jason. You know who you are because you signed up. Just go ahead and step forward. Why don't you line up just to keep it moving? And again, anyone else who'd like to testify, you are absolutely welcome to get in line and testify today. Thank you.
Sure. I'm Jenny Hargraves. I'm at 2231 129th Court. I'm the director for the Miracle Ear Foundation, and I am working in collaboration with Locally Grown, Globally Known, and 3M on this noise ordinance. Our nonprofit is a local nonprofit that helps people nationwide to connect kids and adults with the gift of sound. According to the National Institute on Deafness and Other Communication Disorders, an estimated 26 million Americans have a hearing loss caused by noise. Noise-induced hearing loss affects people of all ages, from children, teens, to young adults, and senior citizens. Left untreated, hearing loss can have a negative impact on overall quality of life, resulting in depression, dementia, social isolation, and even lower income. But noise-induced hearing loss is 100% preventable. A proposal of this magnitude will make a tremendous impact on the well-being of those in Minneapolis, but it will also have the potential to have a larger impact on how we address overall wealth and wellness, as one of the healthiest states and healthiest cities in the U.S. It's something that I think we can do here in Minneapolis. We're proud to collaborate with Locally Grown, Globally Known, and 3M to provide these earplugs at no cost to the establishments, and also limited space and limited work on their part. Thank you.
Thank you for your testimony. Welcome. Please state your name and address for the
Hi
record.
there, my name is Brian Felson, 2296 Sherwood Court. I appreciate the time to address the committee. I suffer from noise-induced hearing loss from custom car audio and attending concerts throughout my youth. Attended many of the locations here in Minneapolis that will hopefully embrace this ordinance. While I do understand the discussion relating to a loss of revenue, I also would like to point out that people that can no longer go to those facilities because of hearing loss or uncomfortable atmospheres will also have a negative effect on revenue, especially in the long term. We're not here to take away their revenue. We're hoping to make the experience of their patrons more comfortable and exciting. Minneapolis is the #1 fittest city named by Shape Magazine. We were the first city to add bike trails and ban public smoking in public places. This is not only an ordinance that are requiring hearing protection to be available, but also it's an initiative for the health and well-being of our citizens, which has a direct impact on the economy and the health and well-being of everyone involved. 20% of kids are affected by noise-induced hearing loss by the age of 18, and if we don't do something proactively to start the conversation and provide the equipment necessary to protect their hearing, those numbers are going to continue to increase, and we're here to make a major impact in a positive way and not impact negatively any businesses.
Thank you for your testimony. Mr. Jones.
Yep. My name is Jason Jones. I'm from 3M. I work in our hearing business. I work over at the 3M Center in St. Paul. Thank you for looking at this ordinance. We see it at 3M as a great educational opportunity. As a gentleman from the University of Minnesota pointed out, new research shows that people don't just lose their hearing from noise over the long haul. Even short-term incidents like events at nightclubs can cause that. We have a gentleman who works with us, Tim Whalen, who went to the 1987 Twins St. Louis Cardinals World Series. From that one event, he ended up with tinnitus or ringing in his ears. He has it every day of his life. People don't realize the dangers of noise, and we see this as a great opportunity to help educate people on it. The providing of earplugs that we've committed to do to get this program started anyway, kind of a first round for everyone, we see as a great opportunity for people to see, you know, the plugs are here, we can try them, we can use them, and get moving on that process. There's certainly some concerns, you know, for folks selling earplugs. We sell earplugs, it's our business, so that's not what we're in the, you know, here to get in the way of, certainly. But really hope that you can look at it as a great educational opportunity. There's a letter that Ted Madison, one of our audiologists, has written for you. I think Brian has a copy of that he'll give to you, but he points out in there, you know, you'd never let people go into a nightclub if they temporarily lost their eyesight, but you let people go into nightclubs and temporarily lose their hearing all the time, and as you know, current research shows maybe that's going to last longer and affect people later in life. So this really gives people that opportunity to think about it. They don't think about their hearing because it doesn't affect them immediately like their eyesight does. So thank you for your time and your consideration.
Thank you for your testimony. Is there anyone else here to speak to this issue? Please step forward, state your name and address for the record. And if there's anybody else, please stand up behind him and state your name and address for the record.
My name's Elliot Miller from New Hope, Minnesota. When I fixed tanks during Desert Storm, I temporarily lost my hearing. There was over 1,200 horsepower. When I went to tractor pulls at the Metrodome, my son, who didn't get any earplugs, nor did I, we had ringing in our ears for a month. It's a cost-benefit situation where if a person has to have hearing aids later in life, we're looking at $6,000, $8,000. This is going to benefit the public. We are going to be in the forefront in the United States. This is an opportunity for the city of Minneapolis to step forward. It's a no-brainer. It's a no-cost. 3M is behind it, the University of Minnesota, Mr. Felsen from LGGK. Please consider it favorably. Thank you.
Thank you for your testimony. Anyone else? Anyone? Anyone? Seeing none, I'm going to close the public hearing. Councilmember Fry.
Thank you, Chair Goodman. I'd first just like to put the motion on the table, and there is a slight deviation from the motion that was initially supplied. I would like to change the decibel level. It's in the first sentence, or second sentence there, from 30 decibels to 12 decibels. So it should read, such single-use earplugs must have a noise reduction rating, NRR, of at least 12 decibels. Thank you for that. I believe it was the second individual that testified. And thank you specifically, by the way, to Mr. Felsen for highlighting this extremely important issue. 12 decibels will be the minimum. 30 decibels, I believe, is the maximum that an earplug is able or capable of guarding against. Second off, this is not necessarily a sexy issue. It's maybe not even politically expedient, but this is very good government. We are tackling something that has largely flown under the radar for the last generation or two. I mean, we've had about 100% increase in the rate of hearing loss from my grandparents' generation to my parents' generation, another 100% nearly increase in the rate of hearing loss from my parents' generation to my generation. And as Mr. Felsen stated, we have 20% of kids that reach the age of 18 suffer from hearing loss. That statistic blew my mind, and it's because they're walking around all day with a stereo set that's strapped to both ears, and they go out to the clubs at night and absolutely ransack their eardrums again. And this is, I think the last individual that testified said that this was a cost-benefit analysis, and indeed it is a cost-benefit analysis. There is a cost, I'm told, by First Avenue of $4,000 per year for the last 3 years. If that's the case, and I don't dispute it, that's one business. However, there are numerous businesses that have extremely amplified sound, and when you're talking about all the medical costs, the insurance costs, MNsure costs of going to the doctor when you have substantial hearing loss, I think the benefit necessarily outweighs the cost. Minneapolis, as Mr. Felsen pointed out, has been at the forefront of progressive issues in the past, and I think this is an opportunity to be at the forefront of progressive issues once again. I know that New York City, San Francisco, Los Angeles, and Chicago have already reached out to Mr. Felsen because they would like to do the same thing going forward because they recognize that it's an important issue for their constituents. So my My motion stands. No, actually, I have one question to ask Ms. Miller, I believe. If you want to just come up to the microphone. No, don't do it.
Ask her offline.
Yep. Ms. Miller, I actually will ask you offline because I do actually care about. I certainly don't want to infringe on any business interests. I understand it was you said it was $4,000 per year, and I'll address that afterwards with you.
Okay.
But thank you for coming to testify. I really appreciate it.
Thank you.
So, yes, the motion is to adopt the staff recommendation with the one amendment of making it 12 decibels instead of 30 decibels.
On Councilmember Fry's motion, Councilmember Reich.
Thank you, Madam Chair. Just one clarification. This isn't going to be a requirement of the customer. It just enables them a choice to make and available a resource to mitigate the sound effects. No one's going to make them. Say, for example, if I want to go see Sonic Youth at 7th Street Entry, not that they would play that venue, I can go ahead and blast Mayor's Way if I so choose.
Further discussion.
Was that a question to me? Yes, these will, it's no obligation for the customer. They will just be available, publicly available, free of charge to customers and employees.
So just again to clarify, it's an opportunity, not something that we're going to police in a nanny state sort of way.
Further discussion on Councilmember Fry's motion. Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That wasn't a very enthusiastic aye. Let's try that one more time. All in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Thank you for being here today. We'll move then on to item number 2. We have a series of public hearings with regard to licenses, so we'll start with item number 2. Mr. Wilson.
Thank you, Madam Chair. The Birchwood Cafe at 3311 East 25th Street is seeking a permanent expansion of premises, and they're adding a new shareholder at the same time. The Birchwood has an on-sale wine license, a strong beer Class D, and they are doing an addition to their building that will allow an additional 24 seats. The requirements based with that were addressed in the zoning and planning commissions. The Birchwood Cafe obtained a variance for parking and rezoning of land used for the expansion, and that public hearing was held in October of 2012. With this expansion, they will have seating for up to 88 persons, and the new expansion area will also be available for neighborhood meetings and things like that, a community room kind of use. A public hearing is required for this application. 196 notices were sent to property owners and residents within 600 feet on March 19th. We did receive 8 responses. 3 are in support and 5 are opposed. The 5 that are opposed generally relate to parking problems, customers parking in the area in front of their homes. The issues were blocking alley with delivery trucks, etc. Part of the parking variance done by the Planning Commission required them to replace any off-street parking needed by the expansion with bike racks, and they have done that. Staff's recommendation is to approve this application.
Thank you, Mr. Wilson. Are there any questions for Mr. Wilson on the application and item number 2? Seeing none, we'll open the public hearing on item number 2, which is an application for an on-sale charter wine and strong beer Class D license for Birchwood Cafe. Is there anyone here to speak to this issue? Anyone? Please step forward, state your name and address for the record.
My name is Tori Johnston. I live in Seward, 2521 34th Avenue South. I moved in there 3 years ago. It's such a charming little restaurant, and this expansion is just really, really changing the face of the neighborhood. We were told at the hearings there wouldn't be any semis. Well, that's simply not true. There's beer trucks coming down my street. There is no parking is already, once, especially in the winter here, now we went to one-side parking. I think the residents will be greatly displaced. I think the added traffic is dangerous. There's a lot of kids in that neighborhood. It's a quiet, nice residential neighborhood, and I wish it would stay that way. I guess you can't stop progress, but.
Thank you for your testimony. Is there anyone else here to speak to this issue? Is there anyone from Birchwood? Oh, sir, please come forward. State your name and address for the record. Is there anyone from Birchwood here? Okay, great. Thanks.
Hi, my name's Paul Carnahan. I live at 2515 33rd Avenue South, 4 houses south of the Birchwood Dairy. As the lady said, the congestion is unbelievable. There's 4 apartment buildings half a block away, so those are 2 lots with 4 units in each lot. We got plenty cars. The traffic in the alley is, I don't even try that end of the alley, and that's the close end for me. It's just not there. The thing that is most concerning, when we signed that parking variance, and there's still a few of us who signed it when we originally, we were told we were signing for a coffee shop with possibly baked goods. And what we got was a full-service restaurant, which has since increased its license at least twice and now doubled in size.
Thank you for your testimony. Is there anyone else here to speak to this issue? Anyone? Anyone? Seeing none, we will close the public hearing. Councilmember Reich.
Madam Chair. Madam Chair, I happily move this forward as staff recommended for approval.
Okay, the motion on the floor is to move approval. Further comments or questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll then move on to item number 3, Boss's Pizza and Chicken. Mr. Wilson.
Thank you, Madam Chair. We have an application by BPC Minnesota LLC, doing business as Boss's Chicken, Pizza and Chicken at 5501 34th Avenue South. The applicants are new operators of an existing pizza-style restaurant that has operated there for many years. Their application today is also, the reason we're holding this public hearing is because they're seeking to have extended hours of operation for the delivery of pizza only. They are allowed to have restaurant hours of 6 a.m. to 10 p.m. during the week and from 6 a.m. to 11 p.m. On the weekends. They are seeking approval to deliver pizza from that facility between the hours of 11 p.m. and 3 a.m. We did do a public hearing notice mailing on this. 43 notices were mailed to residents and property owners within 300 feet. We received 6 responses from that notification. 2 of the responses were in support and 4 were opposed. The opposition related to they generally indicated that they did not want to be woken up between 11 and 3 a.m., for example, by pizza delivery drivers slamming doors, loud car radios, things like that. These are new applicants. We have spoken with them. They believe that they can control their drivers and not make this a problem. The recommendation from staff is to approve this application. We will, of course, monitor the driver's behavior and the complaints that we get, and this is a renewable annual license that we could consider at that time. So again, staff's recommendation is to approve this application.
Are there any questions for Mr. Wilson? Seeing none, we'll open the public hearing on item number 3, which is considering an application for extended hours for Boss's Pizza. Is there anyone here to speak to this issue? Anyone? Please step forward, state your name and address for the record.
Hello, my name is Maria Lopez. I live at 5455 34th Avenue South, just across the street from Boss's Pizza and Chicken. My concern is going to be the noise. We already have tenants in the past in that same pizza place where they were drinking, smoking until 1, 2 a.m., and we don't want that again. They crash into cars during the week, and we don't want that to happen. Please consider that situation. We don't want to have noise and disturbance. We want to sleep and have a neighborhood where we can sleep and have a normal life. Thank you very much.
Thank you for your testimony. Is there anyone else here to speak to this issue? Anyone? Please step forward, state your name and address for the record.
My name is Christoph Baseman, 5412 46th Avenue South. My home address, 5501 34th Avenue South. I'm owner at Boss's Pizza and Chicken. We are very committed to being a good neighbor. We will be training our drivers to no stereos, no slamming your doors. It is in our best interest to be a nice citizen, good neighbor, good community. We want to do good business and not upset the neighbors. So we commit. Thank you very much.
Thank you. Thank you for your testimony. Is there anyone else here who would like to speak? Anyone? Anyone? Seeing none, we'll close the public hearing. We've been joined by Councilmember Johnson. I just want to invite him to say something if he had something he'd like to add.
Thank you, Madam Chair. I really appreciate this opportunity to hear from constituents. We have had messages sent in as well, and I appreciate Christoph reaching out to the Neighborhood Association and to the Business Association and working through these concerns. Obviously, there has been some history in the past actually with this location and some bad activities going on previous to your interest in the property. And so it's very understandable from the standpoint of neighbors, their concerns regarding this. And it's something that I take very seriously. The Neighborhood Association takes very seriously as well. And for that, actually, I'd like to commend you, Christoph, on your outreach to folks and your willingness to work with them. We certainly had a very great discussion with the Neighborhood Association around these concerns, and there are even counterpoints to that, such as having more eyes on the streets from having these drivers there. And certainly when looking at the history of businesses within Ward 12 as well, there have been cases where businesses have generated enough noise and activity that it has been a concern for neighbors, and it has essentially caused issues as well. So I know that I have your commitment to work with neighbors and take these concerns very seriously, and also I understand the economics of trying to maintain a business and make it work when you have limited hours, as is with that. And so based on that, we have talked with staff who have recommended moving this forward and monitoring the situation to make sure that we are taking care of neighbors. And I would sincerely hope all your drivers are silent going in and silent going out, and take that role very seriously within the community, that they are there and there is that impact on neighbors, because that is a serious concern for those living nearby. And I really appreciate as well the residents that we've heard from who have reached out to express worries about that. So with that, I would urge the committee to support the staff recommendations in this case, and I know I'll be working with you and neighbors to make sure that it's a good situation, and I appreciate your effort and outreach in this regard and taking their concerns seriously. Thank you.
I'll move approval of item number 3. All in favor signify by saying aye.
Aye.
Any opposed? That item is approved. On to item number 4, coup d'etat. Mr. Wilson.
Thank you, Madam Chair. Coup d'etat at 2923 Girard is seeking a sidewalk cafe to complement their on-sale liquor license Class B. The sidewalk cafe will have 32 seats. Will be open from 4 p.m. to 2 a.m. Monday through Sunday. The design and layout of the sidewalk cafe was approved by our traffic engineering division. A public hearing is required for this application. 58 notices were sent on March 19th to property owners and residents within 600 feet. As of today, we have received no responses for or against this application. It meets all the requirements of the current ordinances, and staff recommends approval.
Are there any questions for Mr. Wilson? Seeing none, we'll open the public hearing on item number 4, which is an application for a sidewalk cafe license for coup d'etat. Is there anyone here to speak to this issue? Anyone? Anyone? Is the owner here? Very good. Thank you for being here today. Last chance for anyone to speak. Seeing none, I'll move approval of the staff recommendation on item number 4. All in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Thank you for being here today. We'll move on to item number 5, Maddie's on Main. Mr. Wilson.
Thank you, Madam Chair. SMRT Management LLC is seeking a license on-sale liquor with Sunday sales Class B at 43 Main Street Southeast in St. Anthony, Maine. The trade name will be Maddie's on Main. The seating capacity will be up to 190 persons interior, and they do not have any exterior seating plans at this time. They will have conventional hours of 11 a.m. to 1 a.m. Monday through Friday, 9 a.m. to 1 a.m. Saturday and Sunday. This location was for a long time operated by Kikugawa, and they also had an on-sale liquor license Class D at that location. They operated there till just last April. Owners are Dean Schlock, Thomas DeGree, and Brian Gilligan. I believe it's Dean Schlock that has been a longtime owner of the Wild Rose Cafe in Minneapolis, so these applicants have considerable experience in the restaurant business. They have met with our second precinct and talked about their security plans and security issues. This will be a casual theme style restaurant, but they also will have Class B entertainment, which is live amplified sound with unlimited musicians and allows customer dancing. They have given considerable thought to noise mitigation through speaker location and placement and sound engineering to minimize the sound transfer out of that building. Public hearing is required because they upgraded from a Class D to a Class B license. 471 notices were mailed to property owners and residents within 600 feet on March 20th. We also notified the Nicollet Island East Bank Neighborhood Association, Northeast Business Association, and 4 multi-residential buildings were posted in the area. We have received 5 responses to that mailing. 4 are in support and 1 is opposed. The only concern for the opposed one was that noise might leave the premises and get to nearby condos. And again, I've said they have given considerable thought to noise mitigation and will adjust the sound as necessary to make sure it does not violate any codes. They meet all the requirements of our ordinance, and staff recommends approval.
Are there any questions for Mr. Wilson? Seeing none, we'll open the public hearing on item number 5 by the Amazing Wild Roast people for Maddie's on Main. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Fry.
I'd like to support in favor. I'd like to speak in favor. Tom Degree and Dean Schlack have been mainstays in the community, not just in the business sense, but they've rallied around causes, social justice issues, and Wild Roast in particular has been a wonderful place for people to gather, to banter, and I have no doubt that Maddie's on Main will not only retain that kind of community feel, but will also incorporate some of the history, which is from related to the brothels that was occurring back in the 1900s to the 1930s or 40s, and I'm really excited about it.
On Councilmember Fry's motion to approve item number 5, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll move on to item number 6, Royal Hall. This is an application for extended hours. Mr. Wilson.
Thank you, Madam Chair. The Lake Plaza Event Centers Incorporated, doing business as Royal Hall, is a rental hall at 417 East Lake, and they are seeking extended hours to be able to operate on Friday and Saturday from 6 a.m. to 3 a.m. This rental hall had a conditional use permit that did allow hours till 2 a.m. on Friday and Saturday, so this will be a 1-hour extension on Friday and Saturday only. We did notify all persons within 300 feet of this premises. We mailed 52 notices to property owners, and we notified the Central Area Neighborhood Development Organization, Lake Street Business Council, and the Midtown Business Association. We received 0 responses to that, and staff's recommendation is to approve this application.
Okay, questions for staff? Seeing none, we'll open the public hearing on item number 6, which is an application for extended weekend hours, I believe, for Royal Hall. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Cano.
Thank you, Madam Chair. Thank you, Grant, so much for working with us on this issue. East Lake Street, my favorite topic. So, we're working really hard to make sure that we have a cohesive Lake Street culture of healthy expectations about socially responsible businesses, reduction in crime, and definitely making it a place where families and kids and residents can thrive. So I really appreciate your work, Grant, on this. I really appreciate the Plaza's work on this and cooperating with the city and meeting our expectations. And if all things go well, then maybe they can get more extensions because I know their original request was to do a little bit more. But again, we just want to have a measured approach at how we increase activity and the type of activity on Lake Street. We have big plans for what happens on this cultural corridor. And as a board member of Meet Minneapolis, I'm really looking forward to connecting these conversations about how tourists and people from outside of the city come and enjoy Lake Street. So I want to be able to support the businesses to do that in a healthy, comprehensive way. And I'm excited to support this today.
On Councilmember Kano's motion to approve the staff recommendation, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll then move on to item number 7, Ms. Galasper. All right, and it's weird, I know. Usually you're first, so when we might,
I'm
we
not
might have
used
to
to
switch
this.
them up
I was
next
feeling
time.
really left out. Madam Chair, thank you, committee members. My report today is concerning 2 city-owned parcels of land and a recommendation to enter into a long-term lease with the adjacent property owner for the purposes of developing an accessory use to the Baraka Daycare Center. The City of Minneapolis owns the properties at 1913 and 1919 Columbus Avenue South. The city purchased the properties in March of 2000 for $1 each from Hennepin County via tax forfeiture. The parcels contained vacant and blighted structures which were subsequently demolished. During the period between 2003 and 2009, there were efforts made to redevelop these 2 parcels along with 3 others that the city owns that are immediately contiguous to the subject parcels. Ultimately, these efforts were not successful, and the city has continued to hold these parcels and incur property management costs. Baraka Plaza LLC approached the city early last year with a proposal to lease our 2 properties for the purposes of installing a playground for use by the Baraka Daycare Center. The Baraka Daycare Center is located in the adjacent commercial development. Baraka Plaza LLC, the developer, has secured the support of the neighborhood and the council member, and they have also worked very closely with myself and with planning and zoning staff to ensure compliance with city requirements for the proposed playground. City staff are recommending approval of a 3-year lease with the option of 2 administrative extensions of 1 year each, bringing the total potential lease term to a maximum of 5 years. The lease price is equal to $125 per month for both parcels as determined by an independent appraiser. And I also wanted to just briefly mention that since this report was originally drafted, Baraka Plaza LLC has purchased the entire commercial development located at 1910 Chicago Avenue. And there have been some preliminary discussions with them about the possibility of a larger redevelopment that would include both 1910 Chicago Avenue, the location of the current commercial development, the 2 subject parcels, and the additional 3 that are held by the city.
Ms. Glasper, so I was pretty clear that I would only support a 3-year lease. So is there something that's changed between the agenda setting and today? I missed that last portion as the clerk was talking to me. I missed out on the part where you said there was an opportunity to include these parcels with others for redevelopment?
What I mentioned lastly was that since this report was originally drafted, that Baraka Plaza LLC purchased the entire commercial property at 1910 Chicago, and there have been some preliminary discussions with them about the possibility of doing a larger redevelopment project that it would include what is currently there, the 2 parcels that are the subject of this particular report, and then the additional 3 that we hold.
Got it. Okay, great. Thank you. This is a public hearing on item number 7, which is a lease to Baraka Plaza for the purposes of installing, maintaining a playground. Is there anyone here to speak to this issue?
Good afternoon, Madam Chair and committee. My name is Tony Edwards. I'm an attorney representing Baraka, and I'm with the firm of Parker Rosen. Our address is at 123 North 3rd Street, Suite 888 in Minneapolis, 55401. I appreciate this opportunity just to briefly speak, as Ms. Glasper has done a great job of bringing the committee up to speed. I urge the committee to strongly consider not just what's been proposed, but certainly the prospect of a longer-term lease and or additional extensions available under the 3-year lease. Presently, these are vacant lots in what is obviously a very challenged community, and right now they essentially attract opportunities for drug dealing and other crime at night. And this daycare has really represented a positive step, we believe, in enhancing the community. As it presently exists, daycare staff have to bring the children who participate in the daycare across Franklin to bring them to PV Park for play. Obviously, the intention here is to have a playground that is not only allows skipping that step and the safety and logistical challenges that creates of crossing a major thoroughfare like that, but also represents a positive development of what are really ignored parcels within the city. The playground that's been designed has been done at some expense with the help of a local architect. We've got necessary permits as well as the approval of the neighborhood organization, and we believe it will represent a real positive step and an enhancement of what is essentially a vacant lot at this point.
Thank you.
Thank you.
Is there anyone else here to speak to this issue? Anyone? Anyone? Seeing none, I am going to move my own motion, which is to approve a 3-year lease, and then the next step would be to sell to them. That's my point. My point is not to take it away from them. My point is to create a hard deadline where they can buy it. I don't want to be in the business of leasing property. I've been pretty clear about that my entire career. I love this use. I think it looks great. It makes complete sense. If they know today that they have 3 years to figure out how they're going to purchase, they'll be more motivated. So I'm not questioning your motivation. I think there'll be higher motivation. If it's 3 years plus 2 administrative approvals, now we're 5 years down the line. I just don't think that makes any sense. So I'm a big supporter of selling land to people who are doing good things. So my motion is to approve the lease for 3 years with the idea that the organization would determine how they would turn around and purchase the land to keep the playground there permanently going forward, and that's exactly what I said in agenda setting. On the chair's motion, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll then move on to our quasi-judicial public hearings, and I'll turn the chair over to Councilmember Fry.
Thank you, Chair Goodman. Item number 11 on the agenda relates to rental dwelling license conditions. This is at 3701 and 3715 Colfax Avenue North and 3546 Morgan Avenue North. And I'll turn it over, I believe, to Mr. Wilson to provide the staff report.
Mr. Chair, Mr. Fry, Councilmember Fry, which item are we on?
I'm sorry, we're on item number 11. This may not be directed towards you. We're on 8. I apologize. We are on item number 8 right now, which is Chicago Grill Barbecue and Soul Food. It's recommendation to deny renewal of a food manufacturer license due to unpaid citations. Mr. Wilson, can you give us the rundown on 8?
Councilmember Fry, I am pleased to report that all monies owed for unpaid citations were paid today, and this can be canceled.
That is good news. Moving on to item number 9 then.
Mr. Chair, I think a motion would be in order to delete the item from the agenda.
Thank you, Mr. Fussy. I will move to delete item number 8 from the agenda. All in favor, say aye.
Aye.
All those opposed? Item number 9, which is a rental dwelling license for 3111 Upton Avenue North. The owner is Steve Meldahl. The recommendation is to revoke. Mr. Wilson? Who is giving the staff recommendation? Who? All right.
Good afternoon, Chair, Council members. I'm Lisa Smestad, and I'm the manager of the Lead and Healthy Homes Unit in the Health Department. The property involved in this action is a single-family dwelling located at 3111 Upton Avenue North in Minneapolis. The owner of the property is SJM Properties. Since 2009, the rental license application lists Stephen J. Meldahl as the person responsible for the maintenance and management of the property. On February 28, 2013, a lead risk assessment inspection was conducted at the property in response to information received from the Minnesota Department of Health that a child residing at the property had been lead poisoned. On March 13, 2013, the orders were issued to correct the lead-based paint hazards, and the issued orders required the owner not to occupy the property if the unit became vacant prior to a compliance inspection. The owner was given until May 12, 2013 to come into compliance. On March 22, 2013, an appeal of the lead orders was filed. The appeal was heard and was denied. On May 16, 2013, an inspector went to the property for the reinspection and found a new tenant in residence, which was in violation of the orders, and the other orders had not been complied with. Between May 16th and September 13th, the city issued administrative citations for $200, $400, $800, and $1,600. All have been appealed. The first 3 have been upheld, and the last will be heard in April. We have continued to issue citations since that date, and no further appeals have been received, nor have the decisions of the administrative hearing officers been appealed. On September 10th, 2013, a notice of director's determination of noncompliance was issued. The notice indicated that the property failed to meet one or more of the licensing standards and must be brought into compliance within 10 days. On September 24th, 2013, the violations at the property had not been corrected and a notice of revocation was sent via certified mail. The recommendation for revocation is based on the unpaid administrative citations, failure to complete a lead hazard clearance inspection, and reoccupying the property with new tenants while the lead hazard orders had not been corrected despite a specific order not to do so. The property was also posted with notice of license revocation on October 15th, 2013. No appeal to the revocation has been received. Our recommendation is that the rental dwelling license held by Stephen J. Meldal as owner of the property for 3111 Upton Avenue North in Minneapolis, Minnesota be revoked. Thank you.
Thank you, Ms. Lisa. Just one quick clarifying question. So based on what you said, it's my understanding that lead was found in the apartment. Subsequently, a kid got sick from that lead. The city told them remove the lead. They didn't remove the lead. They had another tenant occupy the space. Another kid got sick, and the lead still hasn't been removed?
Chairman, Councilmember Fry, that sequence is not quite correct. There was a lead poisoning. We went in to investigate. Those tenants left the property, and new tenants were moved in. That also had a small child, but that child has not been lead poisoned yet.
Okay, so one child with lead poisoning, not two.
Correct.
Okay. Before we open up to the public hearing to hear from the owner, I will just state that this is a quasi-judicial license hearing for which this committee is limited by law to hearing argument from the property owners or the owner's representative, but is prohibited from considering any further evidence or taking any further testimony. This means that you are required to limit your comments to arguments specifically addressing the evidence or testimony introduced before the hearing officer, which is part of the record that is already before us, so you can't offer any new testimony, and we aren't allowed to consider it. So based solely on the existing record and the arguments that the parties make today, the City Council may affirm, modify, or reverse the recommendation that is before us. So is it my understanding that appeal wasn't even made? So did the administrative law judge actually take testimony in the previous hearing? Ms. Lisa?
Councilmember Goodman, Chairman, I'm sorry.
Fry, it's all right. I just called you Ms. Lisa.
The hearing officers, there was an appeal presented before on the citations, and those were heard, and there's been no further appeal on those, and he did not appeal the revocation of the rental license.
Okay.
Did that answer your question?
I believe it has. Thank you.
Mr. Vice Chair and members of the committee, Ms. Mestad was correct. There have been at least one or multiple hearings on the individual citations that were issued. However, the revocation action, which was noticed to Mr. Meldal, was not appealed, and that's a legal duty that Mr. Meldal would have had he wanted to appeal. He had 15 days to appeal, and he did not avail himself of that opportunity. Therefore, he is prohibited by law from introducing any testimony or any documentary evidence here today. He may make an argument, however, today regarding the record as it exists in front of you, but that's would be the extent of what he's limited to because of the fact that he did not avail himself of his duty to appeal the rental revocation recommendation.
Thank you. Is the owner present today? Please state your name and address for the record.
Stephen Meldal, office address 1223 26th Avenue North in Minneapolis. This particular situation involves a house that I bought 5 years ago. And again, I'll just try to keep it brief. I did drop a small packet off, but I guess pursuant to what I've just heard, you're not able to even observe what the packet entails. I should let you know that I've been doing this for 43 years. I've bought and rehabbed over 300 buildings here in the city of Minneapolis. I've had over, to date, if you count the annual licensing of all of my properties, I've had over 2,000 licenses in that 43-year career. I have never, ever even had a revocation hearing in all those years. Some of the evidence that they've talked about is not correct. There was the previous tenant that was in there had their children tested, which they pretty much all are if they're under 6 in Minneapolis, and there were no issues whatsoever with that child. This particular group moved in, they were evicted. During the child had been in the house for approximately 7 weeks when the child was tested, and the testing did not meet the state law threshold. The threshold is 15 micrograms, and the test report was 14 micrograms. So this didn't even trigger an inspection by state law. Now, they did go in and do the inspection. They sent the orders to the house. They didn't send them to me. They subsequently, the tenant brought them to me because I was evicting this tenant for a number of reasons. My maintenance tech had said that they had over occupancy going, and sure enough, they'd brought other people in, and we've seen a lot of this over the last 4 years in this rental market. I did file the eviction. We went to trial, and at trial, the judge awarded me the property back. It's unfortunate you can't look at the pictures of the property, which totally reflect on the condition.
So, Mr. Miller, I'd like you to stay within the record that's already been presented and the character of the former renter, or the character of the former owner certainly is not relevant here.
The former renter, okay. Yes. Well, I'd just like to state for the record that it didn't meet the threshold to even have the inspection. And I'd also like to state that the subsequent tenants, which obviously you can't look at their lease, but I gave them a copy of the report when they moved in. I've done over 50 lead abatements on 50 different single families and 1 duplex in my career. I know what's entailed. And what I had offered to do was that the tenants, this particular tenant's lease is up May 3rd. They've already been given notice to vacate at the end of the lease. And then I would ask that this be or whatever the legal term would be, because basically what it needs to be done for the abatement is that 9 windows need to be replaced, and the front and back porches, rather than replace all of these windows, we would frame in, like we've done in numerous other properties over the years, install a tandem double pane gelled window in both porches, frame them in, insulate them. The whole house has vinyl siding. The whole outside of the house is totally encapsulated. In other words, the siding's vinyl, the soffits, fascia, window, and door trim are already aluminized, so there's no exposed wood other than the garage. So what we would do would be frame in the porches, match the existing siding with new vinyl siding, and the other issue we would do is just rather than even deal with the garage, because it's the original garage, would be to tear down the garage and haul it to the dump and build a new garage. So I would submit that if they could put this out till July 1st, the tenant will be gone May 3rd. That gives me 6 weeks to get this work done. You can't do this work with a tenant in the property. I thought the tenant was not going to last because we did have an eviction in February, but they came up with their money, and that was the reason they were being evicted. I would just ask, based on 43 years of experience, that I be allowed to make these improvements and repairs, and I can do it easily in a 4 to 5 week period. So I would just ask that we extend it out. I obviously won't, once these folks move out, there's not going to be any occupancy until the permitted work is signed off on by these folks here and also by any building inspector that needs to okay the window installation of the new windows. And again, I've done well over 50 lead abatements on houses in my career, and to try to keep everything moving forward positively, because it is a nice house in a nice area in North Minneapolis, and I would like the opportunity to get that work done. Thank you.
Thank you. Chair Goodman.
Thank you, Mr. Vice Chair. I just had a question for Mr. Meldal, and I also have a question for our staff, too. Maybe I'll start with our staff. Do we have any other potential license settlement issues with this particular applicant, given the number of licenses he has?
Madam Chair and committee members, as I believe Mr. Meldal testified, he has not had a history of any other license revocation. So if you're inquiring whether this might trigger additional license revocation standing on its own, it would not.
And I'm kind of interested in, have 2,000 licenses over time is a lot of licenses. Have there been other times our inspectors have run into this particular landlord?
Madam Chair and committee members, I would have to say that question seeks information which would be outside the record that's applicable to this hearing.
Okay, thank you. Mr. Meldal, why didn't you appeal? I mean, basically, we can't even consider any facts in front of us because you didn't appeal. Why didn't you just pay the citations, and why did you move someone in after you were told you couldn't move someone in? If you have all these licenses and this long history with the city, you would understand how it works.
Well,
so just explain to me why.
Well, I'll show you why real briefly. Over the last 3 years, and it's only been the last 3 years.
You have to speak at the microphone, sir.
Sorry. Over the last 3 years, I have constantly received notices regarding all of my rental properties. And they state that their assessments for unpaid property taxes is almost all of them. Well, Minnesota Tax Court is so backed up, these properties are valued at 4 to 5 times their actual value. So under the statute, you pay your first half taxes, half your second half taxes, which I've done. There's no mechanism in the system to show that these are in tax court unless you actually physically go to the tax counter and see that.
Mr. Melda, if I may jump in here, the question was, why didn't you appeal, I believe?
And why didn't you just pay the fines on the lead abatement before it got to be a whole bunch of fines?
Because we don't pay them until they're assessed. The process is they go to an assessment hearing, and I've been doing this for many years. They go to, and it's a new process in probably the last 10 years. They go to an assessment hearing. Then we appeal them, if we want to appeal them, or we pay them.
You didn't appeal this one. You didn't appeal this long history of things. I mean, the packet on this is this thick. So if the packet on the history of this is this thick, it must mean there have been a lot of citations that you ignored. And essentially, I hear you saying, I ignored them because I wait until I get in big trouble and then I come in and appeal it to a hearing officer. And then I thought I heard Ms. Spistad say, and she can correct me if I'm wrong, we told you not to put another tenant in there. And you did.
No.
Well, I see her shaking her head. Yes, that's what I heard her say. Either that happened or it did not. So
they were already in the property when they said, well, you weren't supposed to. I said, look it. You didn't even meet the threshold to go in there to begin with. And so I said, let's see if we can work this out. We met one other time after that, and I thought the folks were going to be gone, but they've got their rights too. They've got a year lease. I gave them a copy of the report they furnished me. It bothers me that they put in the report that they said that I gave them the report. I walked around and showed them. There's only 2 spots where you have any possible issues. Showed them on both.
Okay, we can't get into the detail of it. I just want to know why you didn't appeal this through the appropriate appeals process.
Because all I do is when I get a notice, which I get all the time now on all my properties, I call whoever has signed it. I leave them a voicemail message. Literally, this is just the last year. There's 80 different notices there, and there's nothing wrong with any of these properties. They're in tax court. Almost all of these are they claim unpaid taxes. The county owes me money.
Okay, well, we're not here to, so basically what you said was I get a lot of notices, so I don't pay a lot of attention to them, so I didn't show up at this hearing.
Because I get them all the time.
Okay, well, that probably doesn't bode well for your case.
Well,
Ms. Minstead, can you just clarify the question with regard to the lead amount?
Madam Chair, the state law allows us to, or mandates that we do elevated blood level investigations at 15 micrograms per deciliter. We are allowed to go down to 10 micrograms per deciliter if resources allow. We have the resources, so we protect our children by investigating all the way down to 10. And just by the way, brain damage takes place at 5 micrograms per deciliter.
Miss Lisa, Councilmember Goodman, are you have any further questions? Miss Lisa, what was the instruction to the owner following that initial inspection where you found beyond the 10?
In the orders, it clearly states that if the property becomes vacant, which it did when the first tenant was evicted, that they are not to move another tenant in.
And what was the finding following that eviction? When the city then came back?
We found a new tenant in the property.
Thank you. If any further questions or comments? Seeing none on that one, well, I guess really on two facts. One, I think we're kind of hamstrung here, even if we wanted to do something, because quite simply the decision was not appealed. Secondly, on one issue alone, which is that the property continued to be occupied following the insistence from the city that it be vacant, I think that's enough. I move that we adopt the staff recommendation. All those in favor say aye.
Aye.
Those opposed? Turning it back to Councilmember Goodman.
Thank you, Councilmember Fry. We have two items that are just sitting on our upcoming agenda I want to note, and then seeing no further business before us, we are adjourned.